Good afternoon. On behalf of CEPS and the School of Transnational Governance of the European University Institute, welcome to our distinguished speakers, our global audience, and our viewers on YouTube to this virtual event titled Leveraging the EU's Power Surplus in Trade and Regulation. I'm Stephen Blockmans, Director of Research at CEPS, and it's my pleasure to open this webinar, which is hosted by the Trigger Project, a Horizon 2020 project on trends in global governance and Europe's role therein, led by Andrea Arenda, who embodies the cooperation between CEPS and the EUI in this field, and to whom I will pass the floor in a moment to introduce the topic and the speakers. But before I do, please allow me to recall that the basis for today's discussion is a paper which Ignacio Garcia Bercero and Kalypso Nicolaïdis published with CEPS and EUI at the end of March of 2021, a paper which resonated also in CEPS's Ideas Lab in June, I think primarily because of the sense of urgency which is felt both within the European Union as well as among like-minded countries elsewhere to strengthen the Union's international role in a world which seems to be increasingly characterized by the rivalry between the US and China. Of course, there is a recognition all around that the EU is not a superpower due to its military capacity, but the EU does stand out as a global regulator and as a prominent trade partner. And in their paper, Ignacio and Kalypso explore possible ways in which the EU can nurture and strengthen this power surplus, as they call it, notably by developing a coherent approach to the external dimension of its regulatory policies, but also by enhancing the regulatory compatibility between its own and others' jurisdictions through cooperation, rather than relying on the rather benign, passive, market-based influence of what is being called the Brussels effect. So we at CEPS, we're very happy to be able to provide the platform for the publication of this prominent paper, as well as the events that have gone before. And we look forward to discussing with you today, increased insights on this power surplus and how it is panning out. So with that, I hand over to Andrea Arenda, who will be the moderator of today's event.
Thank you, Stephen, and hello, everybody, and welcome to our distinguished speakers and discussants and attendees. As Stephen mentioned, this seminar is co-organized by the European University Institute and the Center for European Policy Studies, and hosted by this project that tries to look from different angles and different perspectives as the way in which the EU projects its image and what we define as its actorness into the global governance space. So what we do in the Trigger project is really conceptualizing the EU as an actor of global governance and trying to measure the strength and the features, the characteristics of the EU as an actor in various policy domains. We haven't covered trade so far specifically, but obviously trade becomes at once a policy domain, but also a channel through which, so through trade agreements in particular and trade negotiations, through which the EU also can realize and achieve policy diffusion and seek and pursue its ultimate goals, right? So what we study is the actorness of the EU in various policy domains, but also how this actorness converts into effectiveness in various ways. And obviously the so-called Brussels effect, which Stephen already mentioned, has been perhaps even too often mentioned in the public debate recently as the way in which the EU gets to rule the world. I think one of the merits of the paper that is about to be illustrated and presented by Ignacio and Kalypso is that the idea that one should go beyond the Brussels effect and look at the various ways that the complex set of channels that the EU has to really present and propose its regulatory frameworks to the rest of the world. And also because the Brussels effect typically refers only to, if you wish, the spontaneous emulation of new regulatory frameworks in other parts of the world, sometimes induced, if you take the GDPR as the poster child of the generation of the Brussels effect, induced through ad hoc mechanisms such as adequacy decisions. But they raise a variety of other instruments and other settings and situations in which the EU is actually called to cooperate with others, to negotiate with others, to forge coalitions and partnerships with other countries. And this is not the context in which the Brussels effect materializes. This is a context in which the EU has to interact with other countries, offer solutions, be ready to negotiate common solutions, and to identify common paths with other countries in the future. And it's a completely different area, and an area in which traditionally the academic literature has seen the EU as being less well equipped and much weaker. So let's see if this is somehow reflected in the presentation that Ignacio and Kalypso will give us in a second. But this is a little bit one of the problems that we see today in conceptualizing the way in which the EU presents itself as a geopolitical actor and as an actor of global governance or transnational governance more generally. It's the risk of perhaps dwelling a little bit too much on this idea that it suffices to craft good rules to then have them diffuse through in the rest of the world, and that perhaps strategy and more dedication and more attention to the way in which the EU interacts with the rest of the world perhaps should be, if you wish, a second order type of consideration. I think the paper that is going to be presented in this webinar really discusses in much more detail what the EU could do to exploit what is defined, and obviously this could be subject to discussion, as a power surplus in the regulatory and trade nexus. And so we'll see what the audience thinks about whether this is shedding a new light on the behavior and the strategy that the EU could follow at the global level. So without further ado, I just quickly introduce our two speakers, and then we will move on to our discussants. I will present them after the initial presentation of the paper so that the memory remains fresh on their relative affiliations. So Ignacio Garcia Bercero is Principal Advisor at the European Commission, DG Trade, and is also Visiting Fellow at University of Oxford. And Kalypso Nicolaïdis, who's on leave from University of Oxford, but she's a professor at the EUI School of Transnational Governance. So she's also my colleague because I'm a part-time professor there. So it's a great pleasure to have you with us today. It was a great pleasure to have the possibility to review your paper ahead of the publication. I found it to be extremely stimulating. So what I'll do in order to find it even more stimulating, I'll now shut up and let you talk. And so give the floor to which one of you will, the one that will start the presentation, which, as Ignacio kindly just pointed right now, is going to be Kalypso. So Kalypso, over to you for the presentation of Europe's power surplus.
Thank you so much, Andrea, and indeed the most stimulating prospect of this conversation after hearing your very cogent summary from you and Stephen will be to hear the comments from Liz and Alan, as well as Jacques, and our great audience, whom I know everyone has much experience and ideas about this issue. And let me just say that I'm also really grateful to the collaboration between CEPS and EUI School of Transnational Governance, not least because we're all committed to making this world a better place, including through trade, a belief that we share. So let me very quickly make 3 points. What's at stake? What is the basic criticism of this paper? And what are the broad principles that we propose, to then turn to Ignacio, who will speak about the real things, the specific recommendations that we're led to. So what's at stake, Stephen and Andrea, you've already spoken to this. This paper is a contribution, maybe a provocation, in this long-standing debate about the trade regulatory nexus and how the EU can leverage its market access to exercise regulatory influence outside its territory. We've been speaking about this for decades, I would say, but and including for a long time, and to this day, with the understanding that this is really the one and only issue area where the EU really has a power surplus rather than a power deficit. Now, things have changed recently in at least two big ways. One is that if you speak about power diffusion and exertion, we live in a geopolitical world of power rivalry that are hugely and dramatically heightened, with China asserting itself as a regulatory power with rather different values and expressed in its regulations. So this issue has become not just about geoeconomics, but geopolitics. And secondly, in a post-COVID world, we can all agree that, that we are all trying to think about how we reframe multilateral cooperation. So part of this story, yes, is about power, but power is about how you frame interest on one hand, and asking, well, how does the EU promote its interests, including multilateralism and where that might clash, but also about purpose. And what is the purpose of exercising its power in a world where who defines the rules of the game will become crucial. So that is what I believe we are all after. Now, why did, secondly, Ignacio and I kind of embark on something that, should we call it a critique, Ignacio? This is a debate in which, you know, we all been involved separately, but where Ignacio and I, speaking over kind of a year of his visit in Oxford, really found a certain meeting of mind. But of course, as Stephen outlined, we do speak from different places in this story. Indeed, our paper came more or less at the same time, came out as the EU trade strategy last spring, in which Ignacio was also very involved. So he can indeed clone himself. But the point is that here that you could say that this paper and the EU trade strategy are part of the same spirit, where the paper is more academic, but they're going in the same direction, as Sabine Wayland's recent intervention in The Economist on trade regulation and the environment points to. Very same spirit. But at the same time, you could also say that there is a tone, maybe a sharper critical tone in our paper. And how you read that, it depends on who you are in the audience, and maybe it depends on whether you're Ignacio or myself. And it might also depend on the extent to which you read the Brexit story under this paper. The attentive readers, including Alan, will have noticed that the paper doesn't mention Brexit, but there is also there a kind of mindset, which is to ask, and I think I want to say this at this moment when we see heightened tension around the Northern Ireland Protocol, that I think we share a sense that things could go better from both sides in this conversation and in this saga and in this journey where the UK and the rest of the EU will always be allies and partners. So that's the underlying Brexit story. And of course, when we say critique, you've already said it, Andrea and Steve, the two major challenges or problem that the EU trade regulatory strategy faces could be summarized as both an underuse and an overuse of power. An underuse because, yes, as you've just said, there is complacency in this over-reliance on the Brussels effect. Watch me, we're the best and we have market power anyway. And of course, there's long been empirical studies which question how effective it might be across the board. It depends, of course, on the gradation of issues we're looking at, from purely directly territorially based consumer protection, Brussels effect, for goods and services, all the way to trade and effects and much broader kind of due diligence linkages that are made, and we need to have a conversation about these differences. But across the board, we can say that exporting EU rules in a passive way is not that easy, and it's made increasingly difficult by the global environment, where the EU market size is shrinking, China is rising, the US is more assertive, it's still as assertive as always, etc. Now, the second, of course, critical take is more normative. It's not just complacency, but on the opposite, it's a kind of regulatory hegemony, and asking not so much from a kind of lovey-dovey kind of way, you know, well, you shouldn't be an hegemon, but is it effective to be an hegemon when you want to shape the rules of the multilateral game? Is that the best way to lead by example? And of course, in making this critique, we need to distinguish between at least three categories of countries. You know, weaker countries, the global south, which have less capacity for regulatory convergence on one hand, the other extreme, completely symmetric countries, the US, Canada, Britain, question mark. And of course, in between, the neighborhood countries where the Brussels effect is relied on, you know, systematically in many different ways. So having said that, and to close now on our preliminary remark, our prescriptions are both in terms of broad principles and in terms of specific approach. So let me say a word about the broad principles before turning to Ignacio. On principle, we advocate, I guess, three kinds of shifts: strategy, mutuality, and empathy. Now, on strategy, we've said it, from less passive to more proactive, not just more active, because the EU is very active all over the place, dozens of trade agreements and regulatory cooperation, but proactive in a strategic way. What are we trying to achieve here? What is the overall mindset from our trade regulatory strategy? The second is mutuality. In today's world, unilateralism is condemned by the EU in foreign policy all the time. So should it be the default? Not that the EU doesn't cooperate, but very often it is the default because it can, because it has this power. So the question is, shouldn't mutuality and cooperation, therefore, be the default? Not simply because one uploads and downloads standards from international standards body, but in a much more systematic way, and we will talk more about this, Andrea already did. But thirdly, perhaps most importantly, is this idea of empathy, you know, which again is not about being nice. It's what Alan picked up in his Trade Secrets last June, in asking, you know, how should Brussels exercise its flexibility in how it recognizes the regulation and laws of other countries. And then the question is, why insist on pure alignment when all you really need to protect your firms and consumers and fair competition is regulatory and legal compatibility rather than similarity? Secondly, why not take a leaf from the EU single market, which has used not just mutual recognition, but managed mutual recognition in a very complex way, you know, for decades, acknowledging, of course, that with third country, you're not in the same ecosystem. And indeed, there are issues of trust. And trust is based on information and monitoring or mutual spying, and that's not always easy. Nevertheless, we ask, why is it not possible to engage in a logic of which is more towards mutual recognition of laws and standards, say in professional services, when obviously there is compatibility. And of course, when some conditions need to obtain, rather than unilateral equivalence, or at least when you call it equivalence, how mutual should it be? And one way to capture this concept of legal, this idea of regulatory compatibility is indeed this idea of regulatory or legal empathy, whereby legal empathy is very much the very core, the very heart of European integration. The ECJ, the courts, but also regulators and governments looking at each other, learning to understand the motivation and goals and methods of each other, the means and relation, and asking, how do we work together in a world of regulation rather than become identical? So these are the broad principles. And on this, Ignacio, I turn to you to give us the meat of the topic.
Well, thank you very much, Kalypso, and it's a big pleasure to be here. As Kalypso has said, we started working in this paper when I was in my previous position as a principal advisor and a visiting fellow in Oxford. But we finished it when I was already back in the Brussels bubble, and I was back working on policy, and particularly working on the new trade policy strategy on the European Commission. So you will see in this paper a little bit of the mixture between the academic perspective, but also the policy perspective. Now, I think the basic underlined message is what I think both Andrea and Kalypso have very much highlighted, that there's a risk of complacency if when we regulate in Brussels, we rely too passively on the impact of the so-called Brussels effect. And our basic argument would be increasingly the type of regulations which are being developed in Brussels, particularly we are tackling the challenges which are global in nature or which have a transboundary significance. You can only be effective and you can only be legitimate and you can only exercise influence if you find better and more intelligent ways of cooperating with other countries. And as you develop this cooperation, that would have implications in the way that we structure the policy. A paper at the final section, we make 6 recommendations from a policy perspective. I will just mention them briefly, and then I would like to go a little bit more deeper into one of them. To exercise regulatory influence, we should follow an approach which is based on regulatory compatibility. It cannot just simply be based on expecting others to exactly follow the rules that you are developing. You need to identify how to find elements of compatibility between regimes that pursue similar objectives, even if they may not be identical. The second recommendation has to do more with the way that we do policy in the European Commission. And of course, Elizabeth has a lot of experience on that, but I think if we want to be sensitive to these external dimensions on regulatory policies, we need to factor these elements much better in the process as we develop our regulations. We also need to prioritize. I mean, you cannot be cooperating on everything. You need to identify on which particular areas the Commission should be deploying a particular effort in order to cooperate with their countries. Mostly these are going to be areas which are linked to the digital and the green transition, because these are the big regulatory challenges on which we are currently focusing. Fourthly, we need to look again into how to exploit better the synergies between trade policy and regulatory policy. And that's the issue on which I would like to say a little bit more in my introduction. And finally, there are some specific recommendations relating to our policy vis-a-vis neighboring countries, particularly those countries that have chosen to align themselves with the European Union regulatory model, and also our partnership with Africa. But what I would like to say a bit more is precisely about this question of the trade regulation nexus, how to try to make a better and more intelligent use of this interaction between trade policies and regulatory policies. My basic argument would be that the whole evolution of trade policy over the last 15 to 20 years has shown that we have a bit of an issue that we still need to see how to solve, which is how to deal with regulatory divergences. Now, trade policy traditionally could be seen just as about opening markets and doing this through the negotiation of rules and reciprocal market access commitments. But increasingly, what is most significant when it comes to dealing with access to markets, are not issues that you are going to solve through market access negotiations, are not issues that can be tackled through the determination of rules, are issues which can only be solved if you establish a proper framework for regulatory cooperation. And the question is, how far are trade agreements adequate tools in order to pursue those objectives? Now, I would not want to go into details because that's a whole history since we started dealing with regulatory policies in some of our free trade agreements like Korea, Japan, the whole discussions about regulation when we were negotiating the TTIP, the setting up of regulatory cooperation committees in our agreement with Canada, with Japan, or indeed in our agreement with the UK. But in my view, all of these examples show that there are limits about how far you can take the trade and regulation nexus simply you are reliant on your trade instruments. On the other side, if you see the way that regulatory policies have evolved, I think you see a clear trend increasingly to regulate on issues which go beyond a pure domestic concern of the European Union. I mean, if you look into our paper, we talk about 3 types of regulations. Type 1 is the more classical single market regulation, which is fundamentally aimed at the protection of your citizens against risks associated with the marketing of a product or the marketing of a service. You have increasingly more what we call type 2 regulations, in which in order to achieve your domestic objective, you also need to regulate, or at least you need to be concerned about conduct outside your jurisdiction. And then you have those cases in which you are basically regulating for some global objectives. I mean, you have, of course, to have an impact in your own market, but the aim that you are trying to achieve is some global objectives, where it is the issues relating to climate change, issues relating to deforestation, or indeed other global environmental challenges. And the more that you actually move into these new areas of regulation, the more that you need to be able to develop, if you want to be effective, if you want to be legitimate, an active policy of engagement and cooperation with third countries. Now, one issue that we have not fully developed in this paper, which is I'm increasingly thinking, and I would want to discuss further with Kalypso, we decided to revise this paper, is whether we need to be thinking about new tools that help to better enhance synergies between the regulatory and trade policies. To give you an example, I think an important development has been the decision to set up this year this Trade and Technology Council between the European Union and the United States. Now, we have many histories about trying to develop this one that would be successful. But what is quite interesting about this particular example is that it is an arrangement which is going to be jointly managed by the trade and the regulatory part of the European Commission, and that also implies the trade and regulatory part on the US side. So it's a new type of form of cooperation where you try to bring together in a common project both regulators and trade policy practitioners to see how they can actually work together towards a common objectives. Now, this is something which, of course, is going to be quite interesting to see how it develops. Of course, the United States is a big trading partner, and it's also a significant regulator. Now, the question is how far you are going to be able to develop similar models with other countries which do not have necessarily the same size, the same dimension as the United States. And I think it's always going to be difficult to get the buy-in of regulators if it comes down to engagement with countries of a smaller size. That's what a concept which I think is quite an interesting one. It's something that has also been developed by Bernard Hoekman, is the idea of plurilateral agreements on regulation, or perhaps different forms which can be further analyzed, like, for instance, the idea of digital partnerships, which is something which is beginning to be explored by countries like Singapore, but which potentially you could imagine, why not develop a plurilateral model in which countries that share similar values when it comes to the regulation of the digital economy, including, of course, obviously, privacy as being one of the cornerstones of the values that you share, they actually develop flexible ways of cooperating in order to tackle challenges to the regulation of the digital economy. And there are, of course, many different types of challenges that could be there. You could even argue that the concept of a carbon club, which has, of course, now is attracting a lot of attention because of the CBAM, could be considered to be a form of regulatory partnership among countries that share the common ambitions towards decarbonization, climate neutrality, and ensuring that this is actually implemented in a number of key economic sectors. So all of this is just to say that I believe that if we wanted to find a way of making better use of the trade and regulation nexus, and we are convinced that we are not going to be able to exercise our power surplus without having an active policy of cooperation with third countries, we probably need to be thinking about new tools. It cannot just simply be a question of using our trade agreements. It cannot just simply be a question of regulators on their own developing their own dialogues, their own activities. They are going to have to think more creatively into how the trade and the regulation community can be brought together around specific objectives which can provide a basis to sustain the cooperation over time. And this idea about plurilateral agreements on regulation seems to me to be one which could be particularly promising. So I think I will just leave it at that, and obviously very much looking forward to hear what Elizabeth Alan have to say.
Thank you very much, Kalypso and Ignacio. Thanks also, Ignacio, for reminding me that I presented you in your former position, but not in your current position of director at DigiTrade. It's actually quite fascinating to hear the ways in which each of you approached the paper and presented the paper, and really landed on this idea of exploiting better the nexus between trade and regulation, which is a very good way to start hearing from our discussants, right? Because our first discussant would be Elizabeth Goldberg, who has been a director for smart regulation in the European Commission. She was later at Harvard, and she's an expert, one of the best experts that we know on the EU decision-making and policy-making process. So I assume that Elizabeth will cover in particular the regulatory dimension, but under this perspective that Ignacio was illustrating before. Then we will hear from Alan Beatty, who with his daily newsletter on the Financial Times on trade secrets really helps us on an ongoing basis uncovering the intricacies of global trade. And then we will hear from Jack Beltmans, our very good friend Jack, who's an Associate Senior Fellow at CEPS, and also a very good friend of the EY, and also still a professor at the College of Europe in Bruges. So Elizabeth, I will ask you to get us started with the comments so that Kalypso and Ignacio start taking notes, and then I will ask them to reply to your comments before we open the floor to the attendees.
Hey, thank you very much, Andrea. First of all, I want to commend both Kalypso and Ignacio for trying to put a framework around this rather complex area of regulatory cooperation. And I think you're very brave right now in times where there's a very much diminishing appetite for regulatory cooperation and multilateralism. So bravo. But you know, I come from a regulatory policy background, and I'm a big supporter of an evidence base. So when I was looking through your paper, I identified really 3 areas where I think the evidence could be strengthened in order to make the argument better. And the first one is obviously, is there a regulatory power surplus? The second one relates to the relative benefits of an active approach as opposed to the passive Brussels effect approach. And my third main point is about the conditions for managed mutual recognition. So on my first point, is there really a regulatory power surplus? I think we all know, yes, the EU is a big regulator. We all know that, well, some think we regulate too much. You define power as having influence. And I think there we have had influence for those who want to access the single market. We have influenced that process. We have had influence in political integration processes, whether it was accession in the early days or partnership of our near neighbors and so on. We have had some influence. But beyond that, in the work I did also at Harvard, I think it's the evidence is rather patchy. And certainly to say that there is a surplus of power, to me says that we should be able somehow to measure this. And I don't see that you've given any indication of how you might measure it. And I'd be interested, and I'm sure there are graduate students or people in the academic world who might be very interested in looking at a regulatory power index, if you like. Many academics looked at a soft power index a few years ago. So that's just one idea. So I think my first big question is whether we really have a surplus in regulatory power. My second question or issue that I would like to raise is that you seem to downplay the Brussels effect. Well, from a pure cost-benefit point of view, the Brussels effect it's very effective. It costs nothing. You get countries that are modeling their legislation on EU legislation. And also, through the Brussels effect, you stimulate regulatory cooperation. So if a country is modeling its legislation on the GDPR or REACH or any other big piece of EU legislation, one way or another, they're going to click on the website, they're going to come to a cooperation council, they're going to start asking questions. And I think that's the very basis, the very fundamentals of starting a good process of regulatory cooperation. So I think that we shouldn't discount the Brussels effect. I think it can have some very positive effects. Secondly, in that context, I think that we've tried regulatory cooperation for decades. So as a regulatory policy person, I would like to encourage whomever to do a very serious evaluation of where it's worked, where it hasn't worked, and why. I think that is really called for as an evaluative process. And in that context, I think we always have to remember that the EU is a rule maker. It makes the rules. Regulatory cooperation has always been more successful with rule takers, those who just accept the rules either because they want to come into the market or because they want to integrate. When you take two rule makers together, like the EU and the US, it's always been more difficult. Ignacio and I were very busy in the TTIP negotiations. It is very difficult. We've had breakthroughs with the US, of course, pharmaceuticals, aviation, financial services. I think where there have been breakthroughs, it hasn't been through trade negotiations, it's been through sectoral negotiations. But overall, I think it's been very difficult for the US and the EU to come together in anything more structured than regulatory dialogue or a bit of information sharing or sometimes mutual work, but it has been very difficult. And I can't imagine that would be any more easy with China. So I think it's really necessary in this context to look at what the real challenges of rule makers coming together are. And my third point is on managed mutual recognition. It's hard enough within the EU. I think there has been an evaluation within the past couple of years about the mutual recognition principle, showing that actually it's not used as much as we would like to think. But beyond that, I think, as you point out, it needs a few basic elements. You need shared objectives, you need confidence in institutions, you need trust, and you need some sort of dispute settlement procedure. Now, you might get shared objectives and you might get some confidence in other institutions. But right now, certainly in the COVID pandemic era, I think cooperation has really suffered, whether it's within the EU on vaccines, protective equipment, whatever. And in this process, I think the trust between regulators has really, and between governments has diminished in the last year or so, and it will take time. Trust always takes time to build back. So those are my 3 points: the surplus, the relative merits of Brussels effect versus enhanced cooperation, and whether the conditions for mutual recognition, managed mutual recognition, are there. And if I can make 2 very quick points about the recommendations, I fully agree that it would be ideal if the Commission could better coordinate its external regulatory policies. but my experience has shown that it's hard enough coordinating and ensuring coherence internally, that the resources are stretched to do that. And I think the External Action Service could have played a role there, but the governance structure and the links back into the Commission are not strong enough to do so. So I think that it would be a challenge, and it demands resources and it demands political will. And I think those two things have to come together in order to do this. And the last comment on trade and regulatory cooperation would be that it's no surprise that regulatory cooperation has always fallen under trade mandates, because trade mandates have tended to be easier to obtain. And we have to be honest, whether it's mutual recognition agreements or other things, the focus of trade negotiations has gone progressively to non-tariff barriers. And as non-tariff barriers become the focus of trade negotiations, of course, you're dealing in regulatory cooperation. So I think you will see that. I think they will go hand in hand, but I have to say that the most successful negotiations have taken place outside of the trade negotiations, because trade negotiations tend to be adversarial and regulatory cooperation discussions are not. So with that, I will stop, and I'm happy to further discuss when questions and comments come through. Thank you.
Thank you very much, Elizabeth. Very thought-provoking, very clear in your comments. I'm sure that Kalypso and Ignacio are already preparing their answers to your doubts, but also your request in the spirit of your specialization, request for additional evidence on the existence of the surplus, and also whether we have said the final word on how to spend it wisely if it exists, and also perhaps adding an inch of ambition to the new tools that Ignacio was evoking before, by even pointing at institutional reform in order to really make the EU more well-equipped to interact with other countries in the world in this context. Let us hear from Alan what his comments are. Alan, the floor is yours for your comments on Kalypso's and Ignacio's paper.
Well, thank you very much, and thank you very much for inviting me as a discussant, which is very flattering. It's always a great moment in a journalist's life when they're actually invited to say things rather than just write down things that other people are saying. First of all, I should say about this paper, one of the things I really liked about it is what's not in it, or rather that it dismisses very well, I think, very briskly, a lot of the woolly talk you hear around Brussels about the EU's role as a regulatory superpower and how it automatically gives it influence elsewhere. And this is a huge distraction in the sense that it's hardly possible to discuss regulation within the wider Brussels context without somebody bringing this up. I'm gratified to see, unless I missed it, there's not a single reference anywhere in the paper to open strategic autonomy, which is enormously refreshing, because there's a gigantically, optimistic or misreading of the Brussels effect and the idea that power is somehow fungible and regulatory power gives you influence somewhere else. And I just see this month in, month out. The EU announces a new strategy to do with power in the Indo-Pacific, and I'm just left wondering whether or not it intends to deploy GDPR or the REACH chemicals handbook to the South China Sea. So the sort of realistic and much more targeted emphasis on legal empathy, I think, is absolutely right. There strike me as two constraints here to be overcome, which are mentioned in the paper, but I'd really like to see it looked at in great detail. One is legal, and the other is to do with political economy. Now, the legal one, which I do not have an answer to, particularly not being a lawyer, is precisely how the degree of legal empathy and mutual recognition can be made legally compatible with the EU legal order, and particularly the role of the Court of Justice. The paper mentions the effect of the Schrems decisions, that of course being on the unilateral adequacy finding, not actually a mutual reciprocal finding, and the extent to which that has thrown a stone into what is quite a serious area and quite a serious example of how mutual recognition or how global recognition works, I think is quite considerable, and I kind of like to see that teased out and how that might apply in a bunch of other areas. The political economy one is whether or not extending mutual recognition is going to be to third countries is going to be possible within the EU. Now, the paper makes the point that the EU legal order itself and the EU regulatory order itself is, a network or mosaic or a tangle or a web, I think Kalypso says in another paper, of national competences and EU competences and EU regulatory regimes and national regulatory regimes and so forth. And the way I read the paper's argument is that that could be a model for or complementary to adopting the same philosophy with regard to third countries. That I'm not sure about, because I would tend to look at them as in reality being, in political economy terms, being substitutes rather than complements. The way I've always thought about this is the EU, as we know, is often regarded as a regulatory bully. And as all our parents told us, bullies are bullies because they feel weak inside. And mutual recognition of regulations, I think, struggles even within the single market. We all recall, or we've all read, of how when the single market was created, the UK, which was instrumental in its creation, was very keen on the principle of mutual recognition. And then there was severe pushback from the likes of France and so forth, who preferred harmonization. And there's still this degree of concern, in my view, paranoid, but there it is, that the single market is just about to fall apart. You may remember the Juncker Commission getting weirdly exercised, like properly angry, that companies were selling the same products like chocolate bars and so forth, using slightly different ingredients in the eastern states than they were in the western member states, and genuinely regarding this as a threat to the single market that had to be expunged. That struck me as somewhat absurd, but it does illustrate the point that the concerns exist in the EU about anything but complete harmonization. And I think extending that out with the EU is going to be more difficult. You studiously avoid mentioning Brexit or specifically going through this with Brexit, but this is something that's obviously being tested and being shown at the moment. Even when the EU is displaying flexibility as it currently is, or says it is over the Northern Ireland Protocol, it's displaying flexibility on the implementation of regulations rather than regulations themselves being regarded as equivalent. Now, if there were any entity where you ought to be able to move towards a sense of legal empathy and mutual recognition, it ought to be the UK. It starts off with the same regulations. It starts off with regulators who know each other. And yet there is this strong resistance, there's a strong political economy resistance to mutual recognition within the EU and to losing the supremacy of the Court of Justice, which remains a severe red line when looking at the Northern Ireland Protocol. I'm not saying that's right, but I'm just simply pointing out it's there. Now, you can argue, and you'd be right, that since trust is an essential part of running a mutual recognition, the current UK government is a spectacularly bad example of someone you might choose to try this with for the first time because they're deeply untrustworthy, which is true. However, the point about designing a system like this must surely be that it is proof against future Boris Johnsons, not just the current Boris Johnson, and that emphasizing the importance of trust must also, as Ronald Reagan said, trust but verify must also be proof against, or at least must not expose the EU to risk against the fact that you may well be dealing with regulators or governments in the future which are not as trustworthy. Now, the Trade and Tech Council, I'll just finish on this. The Trade and Tech Council, I think, is actually an interesting way of coming at it the other way, in the sense that it's about sharing information and best practices and so forth. And really, any push to go beyond that, as far as I can tell, the Commission is extremely chary about, because they think that they will get pushback, not just from the Americans who do not want to align, but also from within the member states and also from within parts of the Commission. And so the approach that has been taken is very much, I was talking to people about the foreign direct investment screening, about the export controls. The approach that is taken is very much about sharing information and best practices and trying for recognition, let alone harmonization. So I think this is a great paper. I mean, it is intellectually very courageous, because this is something that a lot of people do not say in the EU, because they've internalized the kind of political economy objections that I've just described, and that circumscribes the debate and it prevents people even sort of discussing it. And Brexit provides an interesting test case, but as to whether it can actually be implemented, that is a political question which I think we're only going to be able to judge over time.
Thank you very much, Alan, also for placing additional emphasis on the internal and external dimensions of this problem, right? Also, the cohesiveness of the EU internally as being one of the determinants, perhaps, of the approach that the EU takes externally, and perhaps also the rigidity sometimes that the EU adopts externally, because when you are not able to flexibly reach compromises internally, it becomes very difficult to act externally with a sufficient flexibility and agile mandate that perhaps would improve the effectiveness of the EU, but they are not in the current, let's say, toolbox that the EU has available. Let's see what Jacques thinks about all this. And Jacques, I give you the floor for your comments. And I'm obviously, I'm pretty sure you will comment also on what has been said until now by the other discussants. So over to you, Jacques, and thanks for being with us.
Thank you, Andrea. Yeah, it's a lovely paper. And it's also in the area that I myself have been very interested in. And from that point of view, it's a very welcome product. I will try to avoid what others have said, not to have, double talk. I wanted to make a few points. A bit about praise, but I was desperately looking also for some criticism. And one has been picked by Elizabeth, so I agree with actually everything she said, but certainly with that one point, so I'll leave that out. First, if you talk about IRC, it's about regulatory. And I will exaggerate on purpose, as we discuss, but aren't we already having an EU trade policy, which is a regulatory trade policy for decades? So now and then, there are a few days a year we talk about tariffs, particularly when it's agriculture, now and then others. But I mean, if you look at the free trade areas, GSP, tariffs are not even important in most cases. Yeah, Trump makes them important, but from our point of view in the EU, so I would say we already have a regulatory trade policy. Of course, the paper goes much further than that, but I think there's an action that it's two separate things. They may have two separate drivers, but what we do in trade policy is for the most part already regulatory for decades. In 1999, EAS, the Asia Institute in Brussels, and CEPS, we organized a EU-Asia trade conference, and I presented a paper there. Trade-driven trade policy is dead. Long live EU regulatory trade policy. And I think that's more the spirit, a bit exaggerated, but also in our voluminous TTIP book that many of you know, we had not a tariff chapter, not one. We had a part of the agriculture chapter on tariffs. Everything else was regulation. And talking about difficulty dealing with the US, each chapter, and there were 15, and there were too many pages, 600, so I apologize for that. Every chapter was written by a US and an EU author together. So we completely internalized the problems that the negotiators had. And that's why the volume took almost a year longer than we had anticipated. But it's not impossible. It's absolutely not impossible. It may be easier for think tankers, that's true. But the other part is the cooperation. And there the OECD has done very useful work, to which I was partly aligned or involved. And if you look at the lower stages of the IRC ladder, this is a ladder of 12 steps, you see that the lower stages are a good deal mellower than even soft lies. But still, even in TTIP, and Peter Chase and I did this paper in that book, there's a lot of attention on procedural issues, especially insisted by the US, on mutual pre-information of upcoming draft laws and all sorts of transparency issues, which is also implicit in the way inside the US regulation is done, especially by agencies. But it's important to see that even very soft things are then greatly appreciated, also by so-called big regulators. But once you get to reference to technical standards, certifications, agreed implementation issues, IRC can harden considerably. So the harden is mentioned in the paper by Ignacio and Kalypso, but that's how I read that. I mean, there's depending on where you are in the ladder. And if you go high in the ladder, it's actually very ambitious. But apart from the praise, because I really enjoyed reading the paper and what some of the others have said, I fully agree why these things are important. I'm a bit surprised that according to Alan, you know, the people he meet all talk about the Brussels effect as if this is automatic. Shocks me a bit because, yeah, among specialists, there's a lot of criticism about it. It's a very nice book, written by a very nice professor with a very nice title, but it doesn't necessarily mean it's all fully correct. So I hope Alan is wrong, but if he's right, I think we have a problem, because that's really not that's not appropriate. I have two pieces of criticism. I finally found two, Kalypso. It took me a while, and I have one other note. The first query is this issue at the term and the function of legal empathy. On that part, I read the paper 3 times in the relevant, and I'll put it a bit bluntly, and I don't mean, of course, this in a very unpleasant way. Do you really need that term or this idea for your paper? Paper has a careful setup, and it's rich in reasoning, and it addresses the points that need to be addressed. And I looked at the definition on page 2. I quote, member states have no choice but to engage with each other's different rules and legal systems. That's the core of what I could find. Yeah, but I see the reason for that is something that is also dramatically underestimated in the public debate, and that's free movement. It's free movement that undermines your regulatory autonomy in the member state, and we accept it as member states. Certainly in the areas that we now talk about, we accept that, and so it's the free movement issue that makes the intra-EU environment so different from the extra-EU environment, because that's not there, and then it doesn't work, or it works only with the greatest possible difficulty. If you are close to the EU, I mean physically, you're in the neighborhood or something like that, or you have a super deep agreement like the EEA, then it might still work. But otherwise, so I think that is for me the core of the issue. Free movement is very, very powerful, the way we have organized it in the EU. Free movement, most people don't realize, is a right of an individual person or an individual economic agent. And the state cannot undo that. And so that is extremely powerful. I think that is really what makes the cardinal difference between the EU and outside. Second query. On page 24 at the top, you write that you limit regulatory cooperation to countries with common values and high levels of protection. Well, I have no problem with that, but the question then is, how many are there? Because the EU is already 27. There aren't that many countries that you could do it. And so I want to offer an experience that Wan who is also watching this discussion, and Wan who is a colleague of mine in CEPS, that we have done in the RESPECT project, so successfully with the EUI and many other institutes, by the way. And in the RESPECT project, we look at whether EU trade policy can promote values, basically. Promote values abroad, of course, and whether it's effective in that. And our job in this gigantic project was to look at EU-China cooperation in sustainable development. Sustainable development is seen as one of the leading values in trade agreements and outside. And so we looked at the social pillar of sustainable development and the green pillar of sustainable. The green is environment and climate. And so that's outside the scope that you define on page 24. And the results of this work wasn't pleasant work because we had to do a lot of digging, but the results are surprising and far too little appreciated in Brussels or the press or you name it. this cooperation in the green pillar has been very successful. But it's cooperation, mind you. It's not legal alignment in the literal sense. In social, it's mixed because it's completely ineffective in the issue of the ILO core labor standards. There is maybe some opening with the CAI, but anyway, it has not been successful in that cooperation frame with China. But it has been very effective also in leveling up social protection in China, where China is extremely keen to exploit, learn, and build on the model in Europe, or the models in Europe. So we conclude that this is, apart from the block of ILO core labor standards, and even there's an exception, because the EU has had an enormously deep influence on improving health and safety in coal mining in China. You never hear about this. And it's really a mighty influence. It's a very successful project. And it's also radical because it went against Chinese management practices in these mines. So I could elaborate on that. I don't want to go too far. So even with a case like China, you cannot expect to be successful in all areas. But if you do a joint management, and also, by the way, often joint funding, and you build up trust over time, you can do a hell of a lot very successfully. And for example, on social security issues, one of the biggest projects in there was taking place inside two Chinese ministries, with the Europeans and the Chinese working together. So it's that far, and that's already 15 to 20 years ago. So what I'm trying to say is, don't necessarily take the view that you necessarily want to have OECD-like countries that have high standards and all the rest of it. It depending on your attitude and on building trust over a long period of time and sustained, you can go even far with China in these areas. Then a last point.
Which you have to make very quickly, Jacques, because you're over time.
It's about technical standards.
Okay, but very quickly.
Another thing people talk about in one sentence, know nothing about, and then go away. There are things happening in technical standards that I had not expected, and here we go. Number one, China had a standardization law for the first time in 2017. There's a lot you can say about that. It's really a change. China has just published 4 weeks ago a new policy document on technical standardization, which is baffling. It's published by the Communist Party and the government together, which is very Xi Jinping-like. And it is really using appealing cooperative language for the first time ever that I know. The third, do you know that the new Director General of ISO, the most important standardization body in the world, is a Chinese? And that's on purpose, because they announced 3 years ago, we want to do the leadership of world standardization. So on that part, we will have to do something. We cannot just say, nice news. And this is fundamentally different from what we have. And then there is the fourth news, then I'll stop. That's on the America side. One of the problems, and Ignacio knows that, I've been writing on this for the European Parliament, on why do we have so many difficulties with working on standards with the Americans? Well, what happened a few weeks ago was the OECD published a surprising report on ASTM, by far the biggest and most important standardization developer of US origin. They're basically now a world standardizer. And the OECD praises them into heaven. Again, I exaggerate a bit, and it makes clear, so it's almost like a political statement, that these kind of standards should be used much more for international cooperation. What I read in that, then I stop, Andrea, is that the conflict we had 6-7 years ago, that these type of American standards are so difficult to fit in with the European system, with a lot of other things that I now cannot talk about, is back on the agenda, because the OECD has here an assessment which is very positive. So both with China and with the Americans, we must do more on international regulatory cooperation via standardization. It's worth it, but it's becoming under a completely new drive. Thank you.
Thanks a lot, Jacques. A very rich comments, and sorry to ask you to hurry up, but just
No, of course.
follow the agenda that we have, and I need to, since it's been a rich set of comments, and I need to give the floor to Kalypso and Ignacio to respond to those comments. Ignacio, well, Ignacio gets all the questions. Then Kalypso, obviously, if you want to add something after Ignacio has spoken, just do it. So Ignacio, I give you the floor. Then there will be more questions. Before I give you the floor, 10 seconds just to remind the participants, as 2 of them already have done, that they can use this Q&A function that you have at the bottom of your screen, or you can raise your hand. In that case, I would need to, in any case, allow you to speak, which is apparently a power that I have under this Zoom, this version of Zoom. I think perhaps the easiest way is either to use the chat or the Q&A function that you have as attendees to this meeting. So, Ignacio, the floor is yours.
Well, actually, there have been so many great comments that it's going to be difficult to answer to all of them. Let me just try a few thoughts, and I'm sure Kalypso will want to develop others. Now, one question which has been raised by Elizabeth is what is the evidence about the power surplus, and to what extent we should not be more positive about the Brussels effect. Well, I mean, if you actually want to look for evidence about power surplus, the book by Anu Bradford about the Brussels effects is full of examples about cases in which third countries or companies have been actually been influenced by the European regulation. So from that point of view, it is clear that there is evidence that because of the size of its market, because of the role that we actually develop in regulation, Brussels has an influence. The question, and that's our critique of the Brussels effect, is can we just simply rely on that influence? And of course, it's very nice when countries follow your lead without you having to do anything. The problem that I think it tends to generate a certain mindset of complacency, which I think I suppose is what Alan was referring to, that when he goes around talking in Brussels, everyone is talking about the Brussels effect. And I think it's clear there's an influence which is linked to the size of our market, which is linked to our regulatory capacity. But our sense is that if you just simply rely on this, you are going to increasingly lose influence. Particularly, you are increasingly trying to regulate challenges which are much more of a transboundary nature, and which therefore require being much more ready to engage proactively with others. Now, I think that both Alan and Jacques refer to the specificities of the single market, the role of the Court of Justice. I would agree with that. I mean, actually, I think when we were actually drafting our paper, Kalypso and myself, we had a lot of discussions about the concept of mutual recognition to be sure that it was not understood about trying to project outside the institutions and workings of the single market. It's clear that that can only really work within a certain institutional framework, which is the framework of the European Union, ECJ, etc. What we are trying to say is that some of the principles underlying mutual recognition can also be relevant for engagement with third countries, but then it's going to have to be much more flexible arrangements, because at the end of the day, all of these arrangements of regulatory cooperation have to be sustained on the basis of mutual trust. I don't think that we're going to have a situation in which you would accept that it's going to depend fundamentally about third-party arbitration. It's going to depend fundamentally about whether or not you can maintain the trust between the regulators of both sides. And that's what I think you need to see how that can be developed under concept of flexible equivalency. It is obvious that the most difficult challenge is always going to be how to cooperate with countries that have a strong regulatory traditions and that see themselves as regulatory hegemons. So the interaction with the United States and China is obviously the most difficult challenge for the regulatory cooperation. I hope that Alan is wrong. I hope that TTC is going to deliver a bit more than some nice arrangements on good practices. I think that the political dynamics behind the TTC would, in my view, not be sustainable for a long time unless it can also deliver some concrete outcomes in terms of regulatory cooperation. And I know the challenges about how to develop that with the United States. We experienced that during the time of the TTIP. We experienced that during the time of the Trump administration. But I think, in my view, in the TTC context, you should really need to see whether you can identify some areas linked potentially to the regulation of the digital economy, where both sides can develop regulatory approaches, which are not going to be the same, but which will be as compatible as possible. And I think a lot of what is going to be explored in the TTC, in my view, is going to be connected to that issue. And yes, of course, in certain areas, you want to be able to cooperate with China. It is going to be much more difficult in areas which are much more value-based, where you actually have a difference of value. But for instance, on issues relating to the protection of the environment, why not? I mean, I'm sure that there are going to be areas where it should be possible for us to develop regulatory cooperation with China. Now, I think that Jacques raised a rather fundamental question about I mean, to what extent is this talk about the trade and regulatory cooperation nexus new, or has it always been that way? Well, it is true that in a certain sense, I mean, trade policy has not been about tariffs and classical market access obstacles for quite some time. The issue that really matter, if you are actually looking into potential frictions or obstacles to access to markets, they have to do mostly with regulatory differences. And most of these regulatory differences are perfectly legitimate. You are not going to be able to tackle them by saying this is contrary to some international rule that we have agreed in an international trade agreement. The only way that you can actually tackle those regulatory differences is you are ready to invest resources on finding a solution which has to be based on regulatory cooperation. The real difficulty is how you create incentives for this to work, because obviously trade policy practitioners have a certain mindset, which is very much, I mean, I wouldn't say necessarily adversarial, as Elizabeth has said, but it's very much geared by the objective of trying to get outcomes to open markets, where regulators, they have basically a mindset which is much more inward looking about ensuring the effectiveness of their regulatory policies. And therefore, the only way which I think that you will actually achieve something more meaningful if you manage to create structures in which regulators and trade practitioners can cooperate, and where we trade practitioners accept that necessarily the driving force behind this cooperation is not going to be on the trade side, it's going to be on the regulatory side. And that, of course, I fully agree with Elizabeth, that's very complicated. That's something that would require political commitment, that would require being ready not to work in silos, that would require investment of resources. And that's why I have to say, I'm not necessarily saying that the challenges that we are raising in our paper are simple. But I think that if we really want to be able to exercise influence where it matters, and what matters is basically the challenges linked to the digital transformation and the challenge linked to the climate transformation, we are not going to be able to exercise influence unless we are ready to invest on these active regulatory cooperation policies. And well, Jack said there's a number of very interesting things about the standards. I mean, it has been a big professional frustration not having been able to establish a good basis to cooperate with the United States on the standards-related matters. And I hope that those who are currently in charge of the TTC will be much successful than have ever been in the past.
And indeed, this paper is in part the child of some of Ignacio's frustration on the actual negotiation front. And so let me just add a few points to add to what you just said, Ignacio. First of all, to echo Jacques, I wanted to say, Liz, on this question of index, that indeed at EUI, we've had this amazing program, Respect, which very led by Bernard Hockman and other colleagues, that is coming to an end, but finding a new goals. And your regulatory power index, very important. There are index and there is evidence laid out there, but especially on our type 3 the more global goals or the values that correspond to more global goals. So I think there's a lot of work to build on there. But in terms of not discounting the Brussels effect, you say, well, if countries call us up, when you were, Liz, doing this, you got these phone calls, right? Take REACH or other areas, of course, GDPR. But the question I want to ask is it not to some extent and sometimes kind of too late to be really effective? So when Jacques says this is an old problem, indeed, Ignacio answered that, we all said, and I started this way, it's an old problem, yes, but of course, it's also changing as regulatory politics are entering high politics these days. But when I was working in the 90s with the OECD, there was this huge regulatory reform program where, my task and others were to ask how are trade-friendly national regulatory reform? How do you duck into another country's regulation? And one of the big findings at the time was, indeed, it should become as upstream as possible. Not wait till you've exercised this Brussels effect and then countries will come and then you have a conversation. So ducking upstream is very important for effectiveness. Neutrality is important to the sense that, of course, there's always two considerations coming in. There is, yes, are we regulatorily compatible or equal, but also equivalent market access, because that's Alan's political economy. Is there enough gain on both sides? And those two kind of have a hard time talking with each other. So we're not just saying that trade needs cooperation, but also that regulatory cooperation needs trade incentives, to happen. And so, and this leads me to combine Liz and Alan. When Alan, and thank you for your comments and praise, but when you say that, well, it's really unlikely, but of course that being unlikely doesn't mean it's not desirable or that and in fact, I would say that there's enough seeds in the way the EU operates, in the way Liz told us, to say that in fact, maybe you are over pessimistic. But as you said, and we all said, there is an issue of trust. But I would say we use this word trust in a way too much. We know it's so important in the UK. But when it comes to committees of technical people, nobody exercises a blind trust. Trust is not a precondition for opening. It's a dynamic effect. It's not about blind trust, it's binding trust. At the end of the day, there will be dispute settlement, as you say. So the question is, do we want a more harmonious or liberal system? And if we do, because that's what the EU preaches and what the UK preaches, then we have to kind of pretend to trust each other and hope for the best. And if it doesn't work, then there is dispute settlement. So and of course we will say, well, the integrity of the single market and all the rest of it, but isn't the integrity of the single market threatened if we don't apply consistent principle? And that leads me to this question of the questions around managed mutual recognition. Because yes, I don't think Ignacio and I are saying, hey, just globalize a single market. That would be naive and ineffective. But we are saying there are deep insights there. And it's not the case that the EU abandoned mutual recognition. Yes, it has a tendency to, the Juncker story is in fact fascinating. And why can't we just love the chocolate that we want to love and call it that? Indeed. But at the end of the day, managed mutual recognition means that there's always some minimal harmonization, but also other ways of playing around. And I would like to put on the table this most important way, that recognition is just not about standards. It's about who certifies to the standards, which is, of course, at the heart of the Brexit story right now. It's about trusting each other for certification, which was the base of the US-EU agreements in the 90s on the MRAs, where indeed that was the question rather than, and at the end of the day, regulatory power is as much about who decides and who monitors the monitors and who guards the guardians of regulation. And so trusting each other on certification, and is one of the big issues that we're talking about. And it's one that actually moved the US game very interestingly in the 90s, because yes, there are regulatory turfs. Yes, Liz, it's so hard to move different regulatory cultures towards each other, but money speaks, and there are huge advantage in division of labor in a highly regulated world, especially now in our type 3 regulations, where you need to rely on local certifiers, and not only Jacques, with countries that have the same values. I mean, I would say actually many in Brazil have the same values, possibly not the current government, but it's in exactly how we actually dock in to the domestic games of other countries and empower others to regulate to our standards and vice versa. That part of this game of managed mutual recognition is played. And just to close here, I would say that the shared concern, and so Jacques, on legal empathy, I mean, this would be a much longer conversation. Watch this space, we'll say much more in our revisions on this and with other colleagues like Lauren Bertin and others. It's a formulation, it's a formulation about a mindset, but it's also a very practical and legal approach to how you deal with other regulation, how you deal with issues of equivalence. There's much more to say about this, but I did want to close on this question of, well, anyway, it's hard enough to coordinate internally. And both Alan and Liz kind of said something about that, and EU cohesiveness. Those of us who kind of speak about European foreign policy in general, not just trade foreign policy, have said that for a very, very long time. And people in Brussels say it too, that one of the biggest obstacles to EU effectiveness externally is how much its positions are already frozen once it goes to the UN or anywhere else, right? And how much 9/10 of the time of external voice is made to get to emphasize process and get to agreement internally. Maybe there's nothing we can do about that, although I think our hope is that the external challenge will act as a trigger to actually have a much more porous understanding of the relationship between internal and external rulemaking and the trade regulatory nexus. And at the end of the day, the EU is best placed for that game of trade and regulation. That's what it's always done. So the question is, if it wants to externalize better that internal game, maybe this will be the trigger, but I speak with caution because Liz has been in the center of that story for many years.
And we're going to give Liz the possibility to, at least in 30 seconds, one minute each, because we are almost out of time to comment perhaps on this. I wanted to say a couple of things. First of all, there are clearly too many good speakers for this panel, and we have made a mistake. So sorry for the attendees, because either we make it like a 4-hour event, or we give you these outstanding speakers one at a time. Perhaps every week or something like this. So I'm enjoying the conversation enormously. Second thing I wanted to say, and it seems to me that in the conversation, what is surfacing a little bit is the need to study also a little bit more whether there are institutional architectural constraints in the EU project that need to be taken into account before one can consider fully whether mutuality could be a starting point. Empathy could be revised and better mainstreamed into the way in which the EU acts externally, and also more generally to go on the first pillar that Ignacio mentioned, whether this can be could give the possibility to revise thoroughly the EU strategy. Second thing that I wanted to say is, Kalypso mentioned the trigger and mentioned internal and external dimension. It's fantastic because it's exactly what we try to do in the Trigger project. So all of you are invited to our next events, and when we start really producing our final recommendations. Third thing I wanted to say, there are some areas, at least an area in which I'm perhaps overexposed at the moment, which is the digital area, where, first of all, it's unclear whether the Brussels effect is so solid, so robust, for the reasons that I will explain. But many people would agree that if there is a Brussels effect today, this Brussels effect is at risk of disappearing going forward. And I'm going to explain why very quickly. So the first reason why the Brussels effect, which comes typically from the GDPR, and especially in the, say, digital technology space, is perhaps undermined by the fact that we still see pretty low levels of compliance with GDPR and quite difficulties internally in enforcing and implementing this rule. So I would just, to leave this as a comment, the comment on bullies that Alan made, perhaps you can be assertive externally, but we know that we have a wound internally with GDPR, and the rules in data protection are perhaps more solid is seen from the outside than they are currently seen from the inside of the EU. The second thing is the GDPR and all the other rules that are being proposed as the EU way to digital at the moment are not really legal rules of the traditional kind, but they are much more aimed at embedding EU principles into software codes. Think about the Gaia-X project, the data strategy, and even the review of GDPR. So it seems to many scholars in this field that, at least in the digital world, rules are becoming much closer to standards, so that in order to perpetuate the Brussels effect, the EU would need to, and echoing also what Jacques said, to really look at the way in which it can behave in the standardization setting in a more cooperative way, but also in a more effective way, so that EU needs a very solid standardization strategy for the years to come. So I leave these comments at that. I have like dozens and dozens of other comments. So what I propose that we do, I'm going to read out loud the 3 questions that we've received very quickly, and then I'm going to give 30 seconds each to first the discussants and finally the speakers. Please stick to the 30 seconds so that we can close in time. So Ignacio was asked for an opinion on the agreement on climate change, trade and sustainability between New Zealand, Norway, Switzerland in terms of the trade and regulatory cooperation nexus, from another Ignacio Aroniz. Anke Ken is asking about the definition of regulatory power. So whether, since the authors use the term jurisdiction in their definition of regulatory power surplus, she would like to know a little bit better what you mean in terms of jurisdiction. You mean the legal framework, you mean something else. So perhaps you can incorporate that in your comments, Kalypso or Ignacio. And Zakaria asks whether the power surplus, if the power surplus is a result of the current asymmetric world order, how can the EU prevent free riding of other power surpluses on the short term? Perhaps I would add perhaps power surpluses not of the trade regulatory types, or perhaps this is what Zakaria meant. So could I ask for very quick comments back, Jacques, Alan, Elizabeth, Ignacio, and finally Kalypso. Okay.
I go first. Okay.
Yeah, you go first.
Well, I will not come back to any of these things. I just want, with a smile, but nonetheless serious, I want to point out about the chocolate directive of 2000. The chocolate directive has almost no contents anymore. So already since 2000, there is no real chocolate regime. All there is in the chocolate directive that is left is about how you label it. So it's a matter of information. So the only market failure that is addressed, of course, in the old chocolate directive, there were no market failures, but people acted as if. That's all out. And what is left is the possible market failure that consumers might get confused between low quality and high quality chocolates. Since about 2004, 5, 6, the Belgians, because it's really about the Belgians, the rest, but the Belgians, have found finally another way to defend their reputation. You know, you have 3-star restaurants and you have 5-star hotels, and you now have the Belgian chocolate sort of informal private regime, which is extremely successful. In other words, if you phone the Belgian chocolate sector, they're not interested anymore in the directive. The problem is solved by the market, but in an appropriate and proper way. And the private preferences of Mr. Juncker are irrelevant. That's all I wanted to say.
Okay. Which brings me directly to Alan. Alan, obviously you can respond to this or any other thing that you've heard. I think you're muted. Alan, you are on mute, so please.
Is that better?
Yeah.
Yeah, that's better.
I'll just very quickly address this question that was actually addressed to Ignacio here about the New Zealand, the HTCTS agreements. Having spoken to some of the people, it's kind of interesting because I say, look, you're just sort of small, you don't have the clout and so forth. And they say, yeah, but what we can do is just offer up a model and see if someone picks it up. And they point out that the CPTPP started as the P4, okay? It started as a trade deal from a small number of like-minded economies, and then it became attractive to someone else. So can those things be potential? Yes, but they have to be picked up by a serious power. They have to be embedded into the, you know, the unfortunate sort of actual power relationships within the economy. That's their role. It's you know, it's potentially an important role, but by and of themselves, they don't do a great deal.
Thank you very much, Alan. Elizabeth.
Yes, just a quick comment. I think it's interesting in the whole discussion today that we really haven't talked about how important stakeholders are in this whole process. And I think that you talk about transparency in your paper. I think it's fundamentally important. And if I look at our experience with TTIP or however you want to look at it, I think that you need to bring all of civic society along with you in any regulatory discussion. Obviously, because regulation touches everyone and there's enormous potential for misunderstanding. So I think that's something that needs to somehow enter the matrix is how do you involve not only governmental organizations, but the whole range of not only industry associates, but also stakeholders. And one final comment just about an example that I'm very familiar with, but it shows the pharmaceutical example. Probably the mRNA in pharmaceuticals with the US is one of the few agreements actually working. But if you look at the history of it, it started actually by various jurisdictions working together on an international basis, and then slowly building up the confidence with each other to sign a mutual recognition agreement. And what I would like to say there is this regulatory cooperation process that takes years, and even after years, there's still a huge challenge in implementation of whatever one might agree on. So thank you very much.
Thanks, Elizabeth. And I know you've done a lot of research on the pharmaceutical side recently, so we're going to have to invite you to present that research sometime soon because it sounds fascinating. Ignacio, over to you, and Kalypso then to also outline what's next and what you bring home from this conversation. And you are also on mute, Ignacio. So.
Now, certainly I bring home a lot of good ideas about the challenges, and I think it's very clear that we are in no way naive about the difficulty of actually implementing an active regulatory cooperation agenda. I think it implies a change of mindset for regulators, a change of mindset for trade practitioners, and it implies also creating the right institutional structures to make this happen. And by the way, I would totally agree with Elizabeth that in order for regulatory cooperation to be successful, the involvement of stakeholders is going to be absolutely critical. Any attempt to engage in these activities without bringing the stakeholders along is clearly going to be doomed to failure.
Thanks, thanks a lot, Ignacio. And Kalypso, over to you.
Jacques, labeling, yes, great, but we live in a world of risk and different attitudes to risk. That is one of the greatest the phenomenon, and so that labeling will not be enough. And Liz's work on pharmaceutical reach, whatever, says it. So to anchor on jurisdiction, you know, our whole paper starts with the territorial notion of legal legitimacy. So that's where we start. And finally, to Zach, yes, power surplus can also be thought about in terms of positive externalities, a gift from the EU to the world, because after all, there is a cost to developing regulation. And the rest of the world has been free riding on this cost. This is another, you know, and complementary angle, but I would say that some trade partners find that the ride is not free, but too expensive. That's kind of the problem. So, but since I'm having Andrea, you gave me the last word. I think Ignacio will agree with me that this has been, a fantastic feedback on our paper. We are writing a revision for an edited volume for Elaine Fahy and her team. And so we will welcome, comments in writing or in any other way. So please, let's continue the conversation, because we very much know that this conversation, as Jacques said, has been going on for a long, long time and will continue to go on. And so, thanks to CEPS and colleagues at EUI, the Respect Project, and Alan, Liz, and Jacques, thank you so much.
Thanks, Kalypso. Thanks, everybody. We are 6 minutes over time, so we had a 6-minute surplus if you want. And we certainly will want to continue the conversation with you once you have also a revision of the paper. So it's been very fascinating. Sorry for going a little bit over time, but this is what you get when you have an Italian moderator, as everybody knows. So actually went pretty well based on those standards. So thanks to all the speakers, discussants, and all the participants. Yeah, we look forward to the revised version and the new versions of this paper. Best of luck for all of you for continuing your research. And thanks a lot. Have a nice afternoon, everybody.
Thank you.